Navigating the complexities of spousal maintenance can be daunting. It's a topic that often arises during discussions surrounding separation, divorce, and dissolution, and yet many people find themselves unsure about its specifics and how the law applies to them. Hello, my name is Victoria Rylatt, and I'm a Senior Associate Solicitor in the Family Department at Anthony Gold. In this video, I'm here to help you understand what spousal maintenance is, and hopefully guide you through the process. So, what is spousal maintenance? Well, spousal maintenance is the financial support that one spouse or civil partner may need to pay to the other following a divorce or dissolution. In some jurisdictions, it's known as spousal support or alimony. Typically, spousal maintenance is paid when one party can't support themselves financially without help. It aims to ensure that neither party experiences undue financial hardship following the end of a marriage or a civil partnership. The law allows either spouse or civil partner to claim maintenance. Entitlement to spousal maintenance isn't automatic. It depends on factors like the needs and resources of both parties, the length of the marriage, and each individual's ability to earn. Courts aim to ensure that neither party faces financial difficulty, especially if one spouse or civil partner was financially dependent on the other. Claiming spousal maintenance follows a structured approach. First, both parties need to disclose their finances fully, so they have a clear picture of each other's circumstances. This will then enable them to evaluate how much the person seeking spousal maintenance might need, or what their monthly shortfall is after deducting their outgoings from their income, as well as the other person's ability to pay. Discussions and negotiations around spousal maintenance, as well as financial arrangements more generally, can happen in a number of ways. One of those is mediation. It's also wise to seek legal advice from a family law solicitor at an early stage. Ultimately, if no agreement is reached, you can apply to the court for a financial order and for a judge to make the decision for you. However, court proceedings should always be a last resort. Spousal maintenance can be paid in two main ways, either through ongoing monthly payments or as a lump sum, known as capitalised maintenance. The latter is a more complex area of law, and both myself and Kim Beatson, the head of our family department, have written a chapter on the capitalisation of spousal maintenance in the new Spousal Maintenance Handbook, which is now available via resolution. Spousal maintenance payments ensure that the financially weaker party can maintain a reasonable standard of living after the relationship ends. Although the length of time during which spousal maintenance is paid does vary. It can be set for a specific period, or in very rare cases for the recipient's lifetime, known as a joint lives order. Whilst joint lives orders were more common in the past, they are now extremely rare, as more emphasis is placed on ensuring that people can achieve financial independence at the earliest possible opportunity. Payments typically stop if the recipient remarries, and the court can also make orders that are either extendable or non-extendable, depending on the circumstances. Spousal maintenance orders are always variable during their term. They can be varied if circumstances change significantly. For instance, if the payer loses their job, or if the recipient's needs increase. Either party can apply to the court for a variation. Job loss can be a reason to reduce or suspend payments. If you're paying spousal maintenance, and this might apply to you, try to communicate with the recipient and consider an agreement, or apply to the court for a downward variation. There are some further key aspects of spousal maintenance to be aware of. Cohabiting with a new partner may influence the amount or need for maintenance. Be transparent about changes in circumstances. A new child can alter financial dynamics, potentially leading to a review of the maintenance agreement. Courts will balance the needs of all involved. Cohabiting partners don't have a legal right to spousal maintenance. However, financial claims can be made for children under a provision known as Schedule 1. If there is a spousal maintenance order in place and you are the recipient, but your ex-spouse refuses to pay, there are several ways to address this. Start by opening a dialogue, and if that doesn't work, mediation, collaborative law, or court enforcement can help. You may also consider an attachment of earnings order, which deducts payments directly from the payer's wages. If you're navigating spousal maintenance or anticipate it, book a 20-minute free consultation with us today. For more information, visit our website or contact Anthony Gold Solicitors at 0207 940 4060. Let us help you secure a brighter future.